Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Here, we bridge the gap between technology and the law, bringing you the forefront of electronic discovery. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery. With over 20 years at the junction of law and technology, I'm excited to help bring together leading experts and practitioners who provide a wealth of knowledge on electronically stored information.
And my name is Brandon Mack. I'm the co-host of our podcast. And with 2 decades of eDiscovery experience myself, I'm also thrilled to be able to participate in bringing you information and education around the world of eDiscovery.
NeLI is not just about discussions. It's about education and it's about collaboration.
Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note that while we engage with some of the brightest minds in the field, the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to another NeLI Pod. And we are joined by Judge Peck. Judge, it is so nice to see you again. Thank you so much for joining us in the virtual recording studio here.
Happy to do so. Good to see you both.
It's nice to see you again. I saw you, as a matter of fact, most recently at the NeLI conference. And that is such a great place to start. If the history books have it correct, Judge, you'll have to keep me honest, you have been to every single NeLI conference since its inception. And I thought, what a great place to start this conversation is to talk to us about how did you first get involved with NeLI? Why do you keep coming back? You're literally there every year, and you're always endorsing it, and you're always saying nice things about NeLI. Can you give everyone listening a little bit of an idea as to why?
I mean, it is a great conference. It is perhaps a little smaller than some of the other eDiscovery conferences, but particularly, for those in what New Yorkers might call flyover country, it is, the biggest and best conference in what I'll call the Midwest, whether that's a correct description of Kansas or not. And it's, it is big enough that it gets at least 5 or 6, sometimes more judges participating. The faculty is the same, A-list faculty that one would see at Legal Week or Georgetown Advanced eDiscovery Institute, but it's small enough, and Robin has added a faculty and all participant dinner after the first night of the program. So really, the participants can get to meet everybody and talk to their heart's content, not only in the formal sessions, but in the other sessions. How I got there is I met Robin and John Sabloni, who was helping her in the beginning at an eDiscovery conference in Boston. And either at that time or shortly thereafter, Robin called or emailed and said, "Hey, we want to do one in Kansas City. Are you willing?" And I said, "Sure." So, and sort of the rest is history. The one footnote, it is true, I've been to all 10, but in full disclosure, for 2 of them, the schedule conflicted once with the Yankee playoffs and once with the New York Rangers hockey Stanley Cup playoffs. And so I didn't want to travel since I had tickets. And so I said to Robin I would video in for my panels and to listen to the other panels. I am always willing to talk eDiscovery, but Yankees and hockey Rangers are my first love.
Well, a person has to have priorities. That's as a lifelong fan, sometimes those things get in the way.
Of course, Robin has brought me twice, no, three times now at NeLI to Royals games, and even gave me a present, and then of course insisted I wear it to the last year's Royals game. So I was sitting there with my Yankee hat on, of course, and my Yankee shirt was then covered by a Royals t-shirt.
Kind of cruel of her to do that to you.
Well,
Well, Judge, obviously you're very well known in the eDiscovery world for the landmark decisions that you've had around the use of predictive coding. And it's amazing for those of us who were in the industry when those decisions first came down to think, wow, that's 14 years ago now that this has been a part of our lives, an accepted part of our lives. When you look back on that decision, as forward looking as it was back then, looking back on it, what do you think about the way in which the industry either embraced or rejected your reasoning in that decision? What might have surprised you about it?
Well, I think the industry embraced my decisions in terms of the use of tar. It didn't embrace it in terms of I would have expected, particularly after Rio Tinto, the second of my tar trilogy. I would have expected there to be much more use of tar. Yeah. It's still, a keyword search industry with tar layered, as a replacement or on top of that. And it shocked me that the uptick or uptake of tar was much slower and remained slower.
That's actually something I'm really curious about. I've always wanted to ask you, Judge, in hindsight, when you look back, knowing what you know now about how it's not really embraced as much as it could, or not really embraced as much as it should, is there anything that you would have decided differently or emphasized more in your opinion, just really considering how this field has evolved so much that may have, and would it made any difference?
I'm not sure it would have made any difference. The problem is lawyers still are a very conservative bunch in terms of use of technology or things like that. Perhaps in Rio Tinto, where the issue of validation came up later in the case, I might have said something differently. Instead, I guess I, like many of the lawyers, didn't really want to do heavy math. And so when they were fighting about doing validation there, I suggested several times to them that they employ Maura Grossman as a special master to deal with them on that. And they were hesitant at first, and finally they agreed to do it. And I was very relieved, and Maura took it from there. And indeed, her career has changed considerably as a result of that special master experience. So it was good for both of us.
You mentioned the fact that lawyers, we tend to be a little bit resistant to change and conservative in the things that we do. Do you think that the evolution we've seen around predictive coding, around tar, moving into Cal and different versions of Cal, do you think that's lessened that in the industry, or do you think that the resistance is still just as strong as it's ever been?
I think, first of all, we have to remember that there is the bubble, the Sedona conference bubble, NeLI attendee bubble, etc., of people who want to learn about tar and other things. And then there is, the rest of the bar that barely knows how to produce emails, let alone, any other newer technology. And for the cases, most cases, it's fine. It is the big cases, the MDL cases, the class actions, the major suits against Fortune 50 companies or whatever that need it. The typical employment discrimination case, even though, the smoking gun documents may well be in the ESI, the typical auto accident, although there may be things in the so-called black box in the car that if people thought about it and tried to get into that data might well determine the cause of the accident or anything else. But most of those cases, they don't think about eDiscovery, let alone use of TAR. And obviously, it takes a certain, it's a much smaller number than I think many lawyers realize. But, you have to have a certain amount of data for TAR to be worthwhile. The other factor that I think still exists is the TAR tax concern. And what I mean by that is if you're doing keywords and you've agreed with the other side on the keywords, however bad the associates or contract attorneys or whoever doing the review is, it sort of is what it is. If you're using TAR, then, the other side may go into court and insist on certain validation protocols or insist that they get a say in how you are doing the TAR process. That cost of going to court may well take the cost savings from using TAR and exceed that. Some lawyers would say, I'd rather use the not as good quality, old-fashioned way of doing it because the judges are familiar with it, than do a better job using TAR, but then have to have motion practice to explain it all.
You mentioned before that some lawyers don't even know how to produce emails. You also made a comment about how outside of the eDiscovery conference bubble, that a lot of folks don't really know as much because we are sitting here recording this podcast. We're sitting at a panel and we're having a discussion. The people that need to be there often aren't there. The people that need to listen to the podcast often aren't listening to the podcast. And so there is a little bit of an echo chamber, but utilizing TAR is kind of like saying like, hey, just go ahead, jump into the deep end. I know you don't know how to swim, but you'll figure it out. There are other tools within the toolbox of analytics and of artificial intelligence, even though people don't call it that. The simple stuff like conceptual searching or doing, name normalization or email threading. There are other tools, but yet they're not being leveraged. What is being leveraged is just, as you said, keyword searching. There's this inertia that can't seem to quite move. What are your thoughts on how do we stop that inertia, even with the smaller things, not even TAR?
Some of it may come about when judges who are now, I think, more sophisticated than the bar can turn to lawyers and say, why aren't you doing X? Or it would save your client money if you did Y. Or the less of a carrot and more of a stick. You are putting eyes on every document that hit on your search terms. When you get to the end of the case, and assuming you're the prevailing party and you ask me to award you attorney's fees, I'm not going to award fees for conduct that could have been avoided by using tools, whether that tool is TAR, whether that tool is threading or deduplication to cut down what needs to be reviewed. There is a little more teaching in law school about the eDiscovery process. I'm amused by certain things. In 2006 or thereabouts, when the first of the federal rule changes dealing with ESI came into experience, lawyers would be before me and they would point to their gray hair or lack of hair and say, Judge, I'll give them every paper memo that the client has. I'll give them all the letters we wrote, but please don't make me deal with email. I can't handle that. That conversation is repeating nowadays somewhat, I am told by my former judicial colleagues, but now the lawyers are saying, I'll give them all the emails that hit on the search terms or, whatever. Emails, no problem, but don't make me look at text messages or Slack messages or any of that. So the more things change, the more they stay the same.
It actually leads into something that we did want to talk about with the expansion of the way in which we're creating data and the different types of data that we see cropping up. I mean, how do you feel about how the industry is keeping up with it? That last comment seems to indicate that we're not necessarily keeping up with it. We still want to kind of sweep it under the rug and say, do I not have to deal with it? Or is there some way I don't have to deal with this? How do we remedy that? How do we not repeat the problems of the past as we continue to see this evolution in data?
I mean, I think the problem is, it would be harder in criminal cases, but the first time you say X method of communication is not discoverable, that's where all the smoking gun documents will go. Yeah. There's no doubt about that. So it is really up to the lawyers, the clients, and if brought before the judiciary, to deal with it both by education and by use of proportionality. But it has to be educated proportionality. There was a case that I covered 6 months ago, maybe, on the EDRM case law podcast we do monthly. And it was one where the plaintiff in the case was a corporate entity. The defendant was a plaintiff, which it was a individual, sort of a flip of the more common case. Plaintiff corporate counsel signed a stipulation saying neither side has to produce text messages and things like that. We will only use emails for discovery. And after the first deposition learned that defendant individual didn't really use email, they used text messages and the like. And so then they came back to, this was in New York State Court, the judge, and said, well, we need this stuff. And the judge basically said, terribly sorry, you agreed not to do that. I'm reading between the lines. I think that the corporate party thought it would be too difficult for them and didn't need it, and et cetera, but they were wrong. We're seeing it now in the hyperlink cases that are coming down. In one of them, I think it was the first of the two StubHub cases, but don't hold me to that. The parties agreed, StubHub stipulated with the other side that they would produce hyperlink documents. And then, lo and behold, figured out that they couldn't do it. And the case went in front of the judge, who basically said, you not only agreed to do this in a stipulation, but you had me so order it. So it's no longer a stipulation. It's now a court order. You should have figured out what you could or couldn't do before you agreed to something. And just, to finish that situation, almost a year later, they did what they were allowed to do under that prior stipulation and order, which is ask for the court to change the requirements for good cause shown. And they came in with all sorts of affidavits from their IT folks and outside consultants saying, well, we may have agreed to this, but it's not possible to do it on a big scale like this. And the court said, okay, you convinced me. You don't have to do it, or you only have to do it for a very limited number of crucial documents or whatever. So it's always, only agreed to what you can do, and, make sure before you agree to carve something out that it's not something where the data you need is going to be.
Oh, there's so much to unpack here, Judge. There's so much to unpack. I was going to go in one avenue, and then you said something else, and I said, all right, well, let me go backwards a little bit here, Judge. Regardless of whatever one's stance is, including your own, Judge, as to hyperlinked documents, modern attachments, you said something interesting, both of the text messages as well as the modern attachments, and that is talking about the ESI orders and talking about making sure that if you have to put something in there to which you agree upon. And so that requires a certain level of education. So, understanding enough about the technology in order to put together an ESI order that allows for both reasonableness as well as proportionality, which obviously goes hand in hand. So there's a bit of an education element there that an attorney cannot be lacking because should they lack
Yep.
in said education, then they are potentially putting their client at risk of not being able to provide all the right information to fully either prosecute or defend the case. Is that, I know it's a bit of a leading question, obviously, but I mean, does that sound about right?
That's right. When I was on the court in simpler times, I had the expression, not to insult anybody, but I called it bring your geek to court day. And what I meant by that was if the lawyers are arguing in front of me or the court generally as to what can or can't be done, it's basically going to be a he said, she said situation, probably with one or both sides not knowing what they're talking about. So bring in, whether it's the corporate IT person, whether it's an outside consultant, bring in the person who can explain to the court how all of this sort of stuff works. And that, really needs to be even moved further backstream. And that is before you agree to do something in an ESI protocol, whether it's a stipulation or an order, make sure you have, as the lawyer, talked with inside counsel, talked with the client's IT people, talked with whoever you need to talk to, and not just say, in the previous case I stipulated to X and it seemed to work fine, so I'll do that again. Doesn't work.
It sounds like there's a role for the geek throughout the entire process, it seems. And honestly, I think a lot of it is going back to some of the earlier discussion we had, the geeks, and I would count myself among those geeks. We live in that bubble and we step outside of the bubble to help people who don't go to those conferences and don't spend time on podcasts like this. But obviously, what we've seen in the last year, the new frontier for the geeks is generative AI. And how does that now get folded into the process? We look back 14 years at your decisions on TAR. Those are the first kind of really big decisions on a new technology. Now we're seeing another new technology that's probably just as big of a leap forward. I'm curious about your opinion on generative AI. Is it really that big of a leap forward? Is it a slight twist? What do you see as its role in eDiscovery?
First of all, I think it is going to encourage greater use of TAR because lawyers won't use the most current, best process. And I've said this publicly a few times, so they'll say, all right, I'm not going to use AI. Oh, TAR, yeah, that's been around enough. I'll use that. So that's good. But then a more serious response to the question, lawyers have to know what they're doing. The biggest thing we've seen with AI are the hallucination cases where lawyers used AI to research and or write a brief to the court. The Matta against Avianca case is probably the most famous of it. And that got, not only legal press coverage, but New York Times and other major newspapers. And yet, since that, there have been at least half a dozen, probably 10 subsequent cases where lawyers submitted briefs with false citations. So that was a problem. That's a different use of AI than using it for discovery. And I guess my concern is, what if I had ruled in De Silva Moore that TAR was no good? So my concern is that the first fight over the use of AI for discovery comes before a judge knowledgeable enough or who becomes knowledgeable enough to deal with it. Because if one gets an early case saying AI is not good for discovery purposes, that'll set use of it back 5 years. The other factors are cost. At the moment, there is certainly a cost to using AI in discovery. It's coming down, as always happens with newer technology. I don't know that even in the big case with companies that can afford to spend a lot of money on discovery, that it wouldn't be cost prohibitive to use AI when you're dealing with a corpus of potentially 1 million documents. So that's a factor. The ability to do the prompts and to do the prompts carefully, appropriately, is going to be interesting to see how that develops. And then, just like there was what I called, and others call the TAR tax, there may be an AI tax. Well, if you use TAR, you may have to disclose certain things, but you don't have to disclose other. If you're using AI and you've got to disclose what prompts you gave the tool in order to cull through the documents, I think a lot of lawyers are going to be uncomfortable with that. And so that's going to be another factor. I am hopeful that if it turns out that AI really can be used well for doc review, and probably the biggest vendor in the industry has an AI for review tool. I won't mention the name to stay agnostic, even though I'm no longer a judge, so I don't have to be. So apparently it can be done. I have not yet used it, so I can't say whether, and there's always the salesperson hype versus how things actually work. So clearly it may or may not be there already, but it will be there in a year.
Judge, I'm glad you went there because so there's two parts that you talked about with generative AI. There's the one part where attorneys can go ahead and utilize a publicly facing consumer grade version of generative AI and just get their research, put it into a motion, submit it to the court. And you're right, to your point, I cannot still believe to this day that there's been about a half a dozen at least different cases post the first one about attorneys not checking the work. It is just seems so absolutely rudimentary and fundamental to quality control check to make sure that what you're submitting to the courts, especially with Rule 11 looming over your head, that it's going to be right, right?
Yes, although I will say this is not a new phenomenon. It's old wine in a new bottle. I mean, before we went to, like constant use of Westlaw and Lexis and all of that, when lawyers were still using the decennial digests and the other tools like that, I could tell by the way the lawyer formatted the discussion of a case that they had just lifted that from one of the print sources. So it's not a new problem, but at least there the case was real. It may or may not have said what they cited it for. Now we've got made up cases. So, but it goes back to the good lawyers versus bad lawyers, and just my favorite thing from Mata is when the fact that Avianca's lawyers couldn't find the cases that Mata's lawyers cited, and then the court said Mata prove that these cases are real. And they verified their work. They asked ChatGPT, are these cases real? And ChatGPT said yes, and that's what they told the court. I mean, you can't make this stuff up.
But of course, if ChatGPT said its hallucinated cases are real, well, then of course, so there's one piece of it, and we could talk about Rule 1.1 and competency, et cetera. But then there's the other part of it, which is utilizing it for purposes of eDiscovery. And my question is whether or not we are going to see a year's worth or maybe 3 or 5 years worth discovery motions about show me your prompts. You alluded to it, and I really want to dig into this one to get your opinion about this, because I feel like what's going to happen is very much like in the TAR days, which is like proving out like, okay, well, what was your cutoff point? Show me what the richness was, et cetera. You can get really, deep and geeky and argue about the TAR. But then there is, well, show me what prompt you use, because did you introduce bias into your prompt? And if you introduce bias into your prompt, then perhaps you have excluded documents that could potentially have been responsive. And then you have a whole other set of issues. And I'm wondering if this is going to be, like you said, it is a new version, same issue, but just a new version, new technology.
Yeah, I mean, I think so. And part of the difficulty, as I understand it, is using slightly different prompts, or indeed, I think even using the same prompt at different times, you can get different results. So, if I were on the bench and this came in front of me, I'm not sure how I would rule on whether that's discoverable or work product or not. There may be entities that come up and become the prompt engineers for anyone willing to pay their money or whatever.
There's a business for everybody.
I don't know.
Yeah, there is.
But
Well,
sorry, I just want to circle back on that one thought that you had there. So, is it? Do you foresee, based on what you said, if I were on the bench now, I don't know how I'd rule on this. Do you sort of feel like because we're going to be spending, there's a possibility that we're going to just be spending so much more money on arguing motions, right? The tax, as you called it, right, about the Gen AI, that attorneys, notwithstanding whether or not the technology can help or not help, people are going to be dissuaded not to utilize it just because that tax is so high.
Yeah, I think so. And that's always the fear with new technology. Now with tar is not so new technology, but we're still seeing fights on its use. To a certain extent, it's economics. Whatever you save by getting through doc review more quickly with AI, are you going to spend it supporting it and worrying that not only are you going to spend the money for the motion, but that the judge might say, no, you got to give the prompts, or worse, you got to redo the doc production a different way.
and Judge, I know you said that you don't know how you would be able to rule on whether or not a specific prompt was defensible because of how slippery that can be, different times of day, different LLMs, things like that. As a whole, if you were on the bench now and you were that judge who had that first case where you really had to evaluate the use of generative AI and eDiscovery to do the review, what would you look at as the elements to determine whether or not the process itself was defensible, or what check boxes the party should be checking as they go through using this in order to say you've done your job?
Part of it is what is being produced. I said in the Civil War, I don't think discovery like this is subject to the Daubert test. If we start saying you got to have an expert to opine on everything you're doing in the discovery process, rule one, fast, just, speedy, and inexpensive will be out the window, at least two of the three of those terms. So are the documents that one would expect to find, and usually there are communications going across the V so that the plaintiff has some idea what documents the defendant has. And then secondly, and this does, although I was not a big fan of validation protocols, it does require a certain examination of what wasn't produced, because, the old, you don't know what you don't know. You may have produced a lot of things that look like you've covered the waterfront, and then you discover that the things left behind as non-responsive are very responsive. So there probably will have to be validation approaches to this. And I think we have gotten to the point, I think, where everybody who uses tar seems to agree that there has to be validation of the tar process. They may not agree on how one does that and how much detail, et cetera, but I think that's going to have to occur for an AI process as well. And fortunately, promo for DLA, we have a whole very advanced AI group at DLA, so I don't have to deal with all these things.
I like that. And you shouldn't have to deal with a judge either. When we look at the pace of where I think technology is going right now, when you see the pace of generative AI and all the various different tools that are coming out, and there's lots and lots of various different vendors who are all waving, I've got a better LLM or a better Gen AI tool than yours. It's clear that it's here. And it also brings about a lot of the issues that we've been talking about throughout the podcast. And I'm wondering, you mentioned the federal rules before. Do you think that the federal rules is going to go through yet another iteration? Are we on like a 5, 6 year cycle? Is it worthwhile to take a look at the rules again, given not just Gen AI, but we talked about before, modern attachments, hyperlink attachments, whatever you want to call them, all of the structured data that we're seeing, whether they be Teams or Slack or text messages or even any other database? There is a lot more than 2006, 2015. Here we are, just started 2025. Should we take a look at the rules again?
Always good to take a look at the rules, but two things. One, as you mentioned, it takes 5 years for a rule to go from being considered or proposed to the advisory committee rules. to actually coming out the other end. It also takes a fair amount of consensus. And going back to 2006, people were upset or surprised that the rule did not specifically refer to email. It referred to electronically stored information, and people were saying, why are you not talking about the current way we deal? And the answer is because it's going to become outdated and the rules are forever. I would think, for example, hyperlinks, that's going to get resolved. All it takes is Google and Microsoft to figure out how they're going to make it easier for their customers to gather the hyperlinked documents that they need. And we're already seeing some changes there. So I think that's going to get the debate on the hyperlinked document production is going to get resolved by commercial, technical, practical things. AI might justify a rule amendment, but I'm not sure what it would be at this point. I mean, one thing I would say is there are a number of judges who, by their chamber rules, have prohibited the use of Gen AI or have said, if you're using Gen AI, you got to disclose it to the court. Problem with things like that is they're badly drafted. I mean, at least one of those rules was, if you're using AI, you got to tell the court. Well, if I use spell check on my brief, do I have to disclose that? It didn't say if you're using generative AI. So one has to be careful that the people making rules know what they're doing. I think we need to see a little bit more what's going to happen with AI for discovery and AI for legal practice before there can be any serious changes to the rules. Because if I were to be the czar of rulemaking, what would I say now? Yes, you can use AI if you do it the right way or something. Does that avoids the judge coming out with a Neanderthal opinion that sets things back 5 years, but I'm not sure it really adds anything. And as I say, it has to be something that both sides of the V agree on. Look at what has happened with the proposed rulemaking on privilege logs. There were a gazillion comments to the Rules Committee in response to their request. And essentially, those who were mostly responding parties, defendants, said it's burdensome. We need a faster and better way to do privilege logs. And the plaintiff side came in, no, the defense bar is just overclaiming privilege, and the problem isn't the logging, it's the review for privilege, and they need to do that, and they need to do it better, which led to the compromise of adding to Rule 26F and 16B that the parties should talk about how they're going to deal with privilege logs. In a way, that's common sense. And secondly, it doesn't give guidance to parties, particularly those who are not as sophisticated, as to what the rest of us are all talking about. So rulemaking is appropriately or inappropriately, depending on how you want to look at it, much too slow and comes in late in the game. And we'll just have to see how AI for discovery comes out before we get into any rulemaking on it.
Well, Judge, in the absence of guidance in the rules themselves, when it comes to the judiciary as a whole, how prepared do you think the judiciary is to deal with the oncoming disputes about new technology, whether we're talking about generative AI and the use of generative AI or other similar disputes that are going to come as technology advances? Is the bench well prepared for handling those disputes and giving judicial guidance to parties?
I mean, I think the younger or newer judges, both magistrate judges who wind up getting most of these discovery disputes, and even the newly appointed district judges are younger, have had more experience as practicing lawyers in dealing with technology. But the other point is judges are generalists, and we have to deal with everything in the federal system, from civil discovery disputes to the criminal docket, and back on the civil side to pro se parties, employment discrimination. I think pro se parties and employment discrimination cases are something like 25% of the federal court docket. Those are not the cases where you're going to have these massive discovery fights. And so, and then, patent and cases that one has never heard of, probably PACA, the Perishable Agricultural Commodities Act, which came before me a number of times, much to my surprise, because I didn't know what it was. And it is incumbent in anything for the lawyers, with or without their geeks, to educate the court. And that remains, whether it's a discovery technology issue, whether it's the merits of a lawsuit, in the patent world and in the product liability world, they often have what's called Science Day with the court, where the parties agree on a leaving one's position at the door, to bring in either the lead lawyers or experts to explain to the judge how a knee replacement product works, or what a certain drug does. And there's no reason why lawyers can't, and indeed they should, say to the judge, we want to get your approval to use AI to do X, Y, or Z. Can we come in before you on a Science Day type approach and explain the technology to you? And most judges, if they're too busy, they'll refer it to the magistrate judge, being somewhat facetious, but not entirely. The judges want to get it right. They also want lawyers to, not fight over stupid things in discovery. But I would say whether one can use AI and how is the sort of thing that judges need to opine on.
It's a good transition to our last question together, Judge. Both Brandon and I have the pleasure of getting to talk to law students. Brandon more than I, and I get to talk to KU law students once a year. Thankfully, there's a professor there who does teach the practical application of eDiscovery to these students, which is fantastic. She does a fantastic job. And one of the things that I said to the students recently, which is they're a bunch of 3Ls, and I said, when you graduate, you are literally at this inflection point in the world of legal technology. And I'm wondering if you were talking to law students, Judge, about how to basically future-proof their practice of law, or how to get out there on the right foot so they don't make some of the same mistakes as some other folks who have a lot of white hair right now, right? What would you say to those law students?
I would say embrace technology, learn how it can make one's life as a lawyer easier, whether it's using AI in discovery, or whether it's even the simpler, using AI for legal research, but using it appropriately, using AI to do first drafts of a letter or an email, some of which is the sort of, I wouldn't say grunt work, but it's the sort of work that if it can be done faster and cheaper for the client by using some sort of technology, you should be doing that, and you should not be afraid, even if you don't know how the tool works, to ask somebody at your firm to teach you, or just, yes, it may not be billable time, but go sit around and play with the tool and figure out how it can make your life easier. AI is not going to replace lawyers. The articles about that are overhype. But it is going to say that the way we practice, the way we bill for tasks is going to change. And you should be the lawyer who has the skill to use that, as opposed to the lawyer who might get replaced because the task they're expert at is now something that a machine of one sort or another can do.
Excellent points. Well, Judge Peck, we want to thank you again on behalf of both Daniel and I and the audience of the NeLI Pod podcast for taking the time this afternoon to join us. Thank you for all your insights and all the information that you shared with us today, and hope you have a fantastic weekend.
Happy to have done so. Great to talk with both of you. And I hope I will see many of the podcast audience on September 11th and 12th, 2025 at this year's NeLI.
Fantastic. That was such a great way to close. Judge, I know for sure we will see you there. Thank you again, Judge.
Thank you.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.